Thank you for joining us today. This is our fifth debrief after the Lee case, and we're here to answer your questions. My name is Roxanne Harrell. I am the legislative director over at Straight Ahead, and I'll pass it to Salim to introduce himself, so we can introduce all of our panelists who are speaking today.
Thank you, Roxanne. Thank you, everyone, for joining us tonight. I believe this is probably our third or fourth info session since the Lee decision. One of the things that we had made that we wanted to really make clear from the beginning was that this was a community effort. This win, the Commonwealth versus Lee decision that was won, was a movement win. And in that process, we wanted to make sure that we were as transparent as possible with the movement, with community members, with people incarcerated and their family members, what's going on with the situation, so that our strength is when we roll together, and having people on the same page, understanding what's going on, makes us stronger. But we also know that it's very important, because what you all are going to hear today, you're going to take back to your loved ones who are incarcerated, and they're going to spread it throughout the prison system so that the men and women, the people inside, can know what's going on. Since the beginning of this process, once we won the PA Supreme Court decision, winning a legal decision is one thing, implementing it is another. And that has been our challenge from day one, implementation. We understood and knew the context of the state legislature that we are working in, because we have worked in this legislature. We have been in this space for the last, I would say, 10 years working within this legislature, and we understand the challenges and the difficulties. We also understand, too, that we're at a much stronger position that today than we were 4 or 5 years ago, 10 years ago. We introduced House Bill 443 through Chairman Briggs, who was on the Judicial Committee. We drafted this bill. We believed that this bill was the appropriate bill for people serving second-degree murder. It was the appropriate remedy, and that remedy would allow people to go in front of a parole board as opposed to go in front of sentencing judges. And one of the reasons that we came to this remedy was because that we know the experience from the juvenile lifers cases, how long these cases can take. And we also believe that it would expedite the process, put it in front of the parole board. And the parole board is built to examine these cases. The parole board is built to examine a person's rehabilitation. And for us, it was really important that rehabilitation, redemption, transformative justice, whatever you call it, was involved in this process. That we didn't want the crime just to be looked at. We didn't want someone going in there and just being judged on what happened, what occurred 20, 30, 40, and in some cases in Pennsylvania 50 years ago. So that bill, unfortunately, was not able to move. In the Senate, the Republicans moved a much more, what we would call a regressive bill, a bill that, and Sean is going to break down this bill a lot more in depth than we are, but this bill basically would have just been a one-size-fits-all mandatory minimum for people serving second-degree murder. It would have practically set a 35-year mandatory minimum, and it would have captured the majority of people serving life without parole for felony murder right now. We did not believe that was a proportional sentence. We believe that bill completely undermined the intent of not just our litigation to abolish life without parole for felony murder, but also the Pennsylvania Supreme Court decision, because it was taking away mitigating factors, individual characteristics of each case. What we did was encourage our allies, and Rick Krajewski is on this call. For people who do not know who Rick is someone who is a member of CADB, is someone that came up fighting in our movement. He started at the coalition to elect the DA, to elect DA Larry Krasner with us in 2017. He was elected to the Pennsylvania House in 2020, and he's been by our side since then. He has been our point person on this. He has been the person that has been making sure that our interests are represented in the state legislature. And more importantly, our bill was preserved. We also had many other allies in the House who also stood with us. Rep. Jordan Harris. Um, um, I'm not going to name them all. We were able to lasso a pretty strong coalition to hold the line. And trust me, when I say lasso, it did take some lassoing. It did take some pulling. It did take some pushing. What we were able to do was run a counter bill to 1400. This bill that moved today is a bill that it's not the perfect bill. I want to make clear that we're not going to have a perfect bill in this legislature. What we are going to do is make sure that we have a bill that we could walk away from and live with. And more importantly, that gives our loved ones on the outside an opportunity to one day be free. So I'm just very briefly going to touch on some of the uh, characteristics of the bill that was passed today and the reason why. So very briefly, it creates a retroactive parole eligibility at 30 years for people currently incarcerated on second degree. It instructed the PA Sentencing Commission to create sentencing guidelines for second degree murder prospectively. That means going forward, creates a system of medical release per the language of HB 150, which we passed out of the PA House last year, creates a system that allows all people, not just second degree, who participate in complete vocational and educational programs while in prison to earn credits that can accelerate earlier parole consideration. By getting the House to plant the flag, we are building a defensive position to ensure that the draconian SB 1400 that was passed in the Senate is not adopted by the House. This is very important. We don't know if what we put forward is going to be the end result. There's still going to be pushing and pulling going on. But what we effectively did was roadblock a terrible bill coming from the Senate and being passed and posed in the House. But I think another important thing that we did was moving it over to the Sentencing Commission gives us an opportunity to take the politicians out of this, because one of the biggest challenge to this whole process has been we have been having to deal with people who are not looking at the humanity of our loved ones. Oftentimes, they are not looking at proportional justice. Oftentimes, they do not even understand the Commonwealth versus Lee decision, felony murder, mandatory life without parole sentences. To them, it is just a political question. Moving it over to the Sentencing Commission is not going to completely take the politics out of it. However, we believe that it will reset the board and allow a commission that theoretically was designed to determine and handle sentencing guidelines in Pennsylvania. It is supposed to be nonpartisan, and our role as a movement has always been to hold power accountable. Our role in this process is going to be to hold that PA Sentencing Commission accountable to develop an appropriate sentence going forward for felony murder. So we reset the board, we roadblocked a terrible bill in the Senate, and this is where we're at right now at this moment. Again, there's still work to be done. This process is not over. So what I'm going to do is, because I don't want to take up all of the time, I'm going to move it over to Roxanne, and folks are going to give everyone a very detailed breakdown of each thing I very broadly touched on. Roxanne?
Yeah.
Thank you.
So Salim already kind of touched on this already, but I'm going to give you a breakdown of SB 1400 and then HB 1042, which is the bill that just passed out of the House today. So some of you might be wondering over the last few weeks, like, SB 1400, why didn't the Senate go forward with that bill? And I just want to emphasize that it's a good thing that they did not, because it's a really bad bill. So, and we've always held the line of we rather go to resentencing than pass a bill that would have a worse result than what people would get, in resentencings. And we believe SB 1400 would be that. And so just to do a quick breakdown of the bill, we actually made a little fact sheet. I don't know if somebody can share that in the chat so people can take a look at it. That breaks down some of the elements of the bill. But just to go over it real briefly here, retroactively, what SB 1400 does is that it makes people eligible for parole after 35 years, except if you're, I think if you're convicted of sex offenses or killing a law enforcement officer, or I think a child under 13. Like those are exclusions in the bill, which we believe that are unconstitutional to have that bar. And it also allows people over 70 to seek parole after 20 years. And so this is actually a bit deceptive because it seems like they're kind of, making something a bit more reasonable. But actually, the amount of people who would qualify under that is 9 people. And so it's a bit deceptive that it does not impact a lot of people, but they can point to something that they're doing. Oh, look, we're giving, people over 70 a break, basically. But a lot of those people would have been eligible anyways after 35 years because many people are not, out here committing crime after 50 years old. And that's just the reality of the demographics, right? And so that's what it does retroactively, more or less. And then prospectively, it's actually, really, punitive as well. So it's basically a bill that is a 35-year to life or life without parole bill. And then it has like these mitigating categories that is an affirmative defense that is basically impossible to fulfill, right? So it creates the illusion that they're, considering culpability in an offense, but actually the test they're using to determine that is impossible to fulfill. And so, we oppose this bill. We believe 35 years mandatory minimum, which means people can get higher sentences than 35 years. 35 is the minimum of what they can get, and is too high. And like if you're not able to determine like the culpability of somebody who's involved in a felony murder case, which is really wide, like there's a wide variety of behavior that can get you convicted of felony murder. We just believe that's way too punitive. And in fact, SB 1400 is among the most punitive bills in the entire country. We did a bit of analysis of, bills in other states, and SB 1400 falls like really like in like the top 3 like most punitive bills for felony murder like in the entire country. And so we just believe that it's not a good solution, and it would be better to go to resentencings and have people go in front of their sentencing judges, especially in places like Philadelphia where they would probably fare a lot better than 35 years. And statewide, we believe people would fare better than 35 years as well. And so it's a good thing that the House held the line and did not pass SB 1400. Now to get to HB 1042. I feel like people might be a little bit confused as to what happened in the last couple of days. We realized that things were moving very fast, and people might have been afraid they were passing what the Senate, passed over the House, I guess, a couple weeks ago or last week or whenever that was. And what they did today is they amended HB 1042, to include 30 years, a 30-year retroactive active provision for people sentenced to felony murder who are currently incarcerated. But what they also did is add the language for HB 150 in it. So the reason that we did this, like the 30 years we understand is a compromise. It's not what we ideally would want, but in order for us to accept a 30-year minimum without like a clear prospective statute as well, there needed to be, another, I guess, pathway that we wanted, for release for people and relief for people inside prison right now. And so that was HB 150, which has been the most vetted bill, and it actually passed the House with like 12 Republican votes last year. And I believe, Rick will probably talk a bit more about that, a little bit later, because that's his bill. And that was able to pass out of the House with 102 votes. And so with that, I'm going to pass it to my colleague, Sean Damon. And if all our speakers can introduce themselves as they begin speaking, that would be wonderful. Thank you.
Awesome. Thanks, Roxanne, for that breakdown. And thanks, Salim, for framing everything out at the outset. My name is Sean Damon. I'm the Director of Strategic Partnerships for Straight Ahead. And I want to kind of like draw back the lens a little bit, and just think about the kind of long haul that we've been on. For over a decade, our movement has fought in a variety of ways to create the possibility of a second look for people sentenced to die in prison. We have fought for a right to redemption, So those who have turned around their lives might rejoin their communities and be reunited with their families. And, just the principle here is that we believe that we shouldn't permanently warehouse people in prison who have worked to rehabilitate themselves and do so at a great expense to Pennsylvania taxpayers. So like years ago, we pushed for reasonable resentencings for the juvenile lifers after the U.S. Supreme Court found their mandatory life without parole sentences unconstitutional. And in large part, we won that fight. Hundreds of juvenile lifers have come home, and they are one of the most successful cohorts of people coming home from prison with a vanishingly low recidivism rate. We fought at the Board of Pardons, and we were able to bring some people home that way. Not everybody. It's not the system we would like, not nearly enough, but every single freedom victory is precious. So we have to celebrate all of our wins. Straight Ahead's legislative director, Roxanne, who just spoke, her husband came home and came home through the Board of Pardons, and they met and they built a family together. And that family is about to get a little bit bigger in a few weeks. Nancy Leiter, who I don't know if Nancy's here tonight, but she's often at these meetings. Nancy advocated for two men to come home who took part in a crime that led to her father's death. And she was able to have a dialogue with them that led to some healing. So all of our wins matter because they are people's lives and their freedom to be with their families, to live at peace, to seek justice that is restorative and transformative. And with that said, it cannot be understated enough, like Salim said, on March 26th, we scored a huge victory in the PA Supreme Court in the form of Commonwealth versus Lee. And I'm going to talk a little bit about what did and what did not happen in Harrisburg, but no one can take that win away from us. People are coming home, and I know y'all are on mute right now, but just while you're on mute, I want you to say it with me. People are coming home, right? People are coming home. Now, the deadline for the legislature to act it's going to pass. There's nothing that's on the governor's desk. But what happened here? Why weren't the politicians in Harrisburg able to get something done? And so you guys need to know some background here. The first thing you need to know is, as Salim sketched out at the beginning, as Roxanne mentioned, we worked very hard to get something across the finish line, and we are willing to compromise on a number of points in order to create a fair and equitable system that would bring people home as soon as possible. We assembled a coalition that contained public defenders, organizations that work on criminal legal reform. We coordinated with our district attorney here in Philadelphia on what he wanted to see in terms of policy. We talked to countless lawmakers, and we had extensive negotiations with the Pennsylvania District Attorneys Association, which does not include the Philadelphia DA. And the Office of the Attorney General was also in on those conversations. In the end, the other side did not want to compromise. They are used to an old way of doing things in which, during the rise of mass incarceration, the DAs across the Commonwealth were allowed to essentially write criminal justice policy at the state level for decades without any counterbalance. And that, in large part, led to the mess that we're in, where we started with about 8,000 people in prison in 1980, and just 2 decades later, we had about 38,000 people in our state prisons. Now, because the other side was not willing to compromise, in the end, the Senate Republicans and the Office of the Attorney General played political games that derailed serious attempts at reform. They introduced SB 1400, which Salim and Roxanne broke down, an extremely flawed bill that would have given the vast majority of people convicted of second degree a 35 to life sentence going forward, or worse, right? Retroactively, it set parole at 35. It's far too harsh. And let's keep it 100. This would disproportionately harm Black communities in the Commonwealth, where over 78% of people serving one of these unconstitutional felony murder sentences are Black. Okay. This bill was not designed to be a conversation starter, but a conversation ender. There are people on the other side who honestly believe they could get the governor on board with some form of this bill and ram it through the PA House of Representatives. But this is where they simply did not get the memo on how things have changed. As I mentioned at the outset, we have been building our movement for over a decade, and we have brought people home. But we haven't done that just by luck. We have built our skills, our capacities, our grassroots base of support, our coalitions, and through all of these things, we have built our power. 10 years ago, organizations such as ALC, Youth Sentencing and Reentry Project, Amistad, Atlantic Center for Capital Representation, and many others were just in their infancy. The Public Defenders Association of Pennsylvania existed, but had no paid staff. And Defender Association of Philadelphia did not have dedicated legislative staff. In the last decade, progressive champions like Rick, who's here tonight, have been elected in office. Our Philadelphia DA is one, but there's many state reps and there's folks in the Senate that are champions for us. We have made some changes in the world. So when the other side tried to force this awful bill on us through the Senate, we had some power to stop it. And today, through our allies in the House, we were able to respond. The bill that passed today, with the support of our movement, was based on a compromise, right? It was a compromise, not exactly what we wanted, but we made that compromise to actors on the other side. We always told the other side, we are willing to negotiate in good faith, and we're willing to compromise to create an equitable and just process for people serving these sentences, but we will not do one thing, right? We will not put people in a worse spot that they would be on average through mass resentencing. We believe that the same PA Supreme Court that ruled that these mandatory life without parole sentences for second degree are unconstitutional will eventually make this retroactive and will order mass resentencings. In Philly, we have over half these cases. That means that most people are going to get very reasonable sentences through our courts, much, much less than 35. We made that clear to the DAs and the Office of Attorney General. And we made clear that we would stop such an awful proposal as SB 1400 in the House, where we have a good deal of support for our position and for the communities that we serve. Okay. We encourage them to be sensible, to reach an agreement with us that would pave the way for all of us getting something done in Harrisburg. But in the end, they would not listen. And so when we hit the 11th hour in Harrisburg, while lawmakers were finalizing the state budget, our political allies were being asked by leadership if certain compromises would work. And in turn, they were checking in with us. And we made it very clear to the other side that if they wanted to leave the sentence going forward undetermined, or if it was a bad sentence that contained a lot of mandatory minimums, they were going to need to do something to get more people who've been stuck in prison for decades out now. They needed to either lower parole eligibility to 25 years for second degree, or to lower it to 30 and pass medical release, which would get hundreds of people who are very, very sick and could receive treatment out in the community out of prison every year. And we said, you got to do one of these things or there is no deal on our end. We will not concede on every point at the expense of our communities. And so we told our political allies, there's no deal. And to their great credit, House leadership stood by our side and they refused to run that awful bill, SB 1400. And not only that, today they ran and passed one of the compromise positions that we had put out there to reach an agreement with the other side. We applaud them for that. And so there's many thanks to Rep. Rick, who's here today, Chairman Briggs, Chairman Harris, and House leadership on that front. They deserve some accolades for standing shoulder to shoulder with us in this final moment, okay, and holding the line against 1400. So in the end, the other side, they acted arrogantly and they tried to force their position on all of us and have PA taxpayers foot the bill to keep more people in prison for a longer amount of time. And we were able to stop that very bad bill that would have not given many people second chances. This has set us on a course we are very likely headed to mass resentencings. Many hundreds of people will come home in the coming years, but this fight is not over. This fight is going to move to supporting our people in court and to fighting for the resources necessary for public defenders and others to be able to conduct these resentencings in a just manner. And I cannot underscore this enough. We are going to need to organize ourselves for court support and very much to fight to see the state fund this mass resentencing effort, especially the public defenders who are underfunded as it is. And the fight is also going to move to guard against the possibility of 1400 being resurrected in some form this fall, or early next year. Anytime before there's another Supreme Court decision that orders the mass resentencings. So even though the deadline is passed, we're going to remain vigilant that a bad deal isn't forced on us. And very much the fight will move to building the power we need over the long haul, right? I said this last decade, we built some power, but over the long haul, we need to build more so we can win a rational sentencing policy that prioritizes giving people a second look and affords people who have done the work to transform themselves a path home. I've talked tonight about how we have built the power to have a seat at the table. We have to keep building that power, building our capacities, building our networks, so we can win second chances and bring this era of mass incarceration to a close. So how we're going to build that, it's in the struggle before us, right? It's in the act of supporting people with these unconstitutional sentences as they fight for a right to redemption. But if there's anything this movement has taught me, it's that when we fight, we win. And again, I know y'all are on mute, but I just want you to say it with me and feel it in your heart, right? When we fight, we win. And with that, I'm going to pass it to one of our most steadfast champions in the PA House, Rep. Rick Krajewski. Rick, thank you so much for your work today and every day throughout this fight. And thank you so much for joining us tonight.
Thank you. Good evening, everyone. It's a good feeling to be here after today. To be here with comrades, with friends, with people I haven't seen in years. I think I saw Giovanni on the call. I haven't seen that brother in a long time. So it is, it's great to really be with folks after a real battle where we were fighting for our people and for our values. And so, yeah, I actually forgot to introduce myself. So for those of you that don't know me, I am Rick Krajewski. I currently serve as the state representative for the 188th Legislative District, which is in West and Southwest Philadelphia. Before that, the way I met a lot of folks on this call was when I was shoulder to shoulder with you as an organizer in Philadelphia, fighting to bring our folks home through CADB, getting Larry Krasner elected as district attorney, and fighting this fight to make sure that we can change our carceral system to an actual justice system. And I want to echo something that Salim mentioned briefly in his opening remarks, which is that, the Lee decision itself is a monumental victory, something that is truly the manifestation of the organizing and work and litigation of everyone on this call and everyone who's not on this call. That win cannot be taken from us. And also, once that win happened, and once the Supreme Court said, the legislature has 120 days to respond, that legal environment then became a political environment. And that is what myself, Sean, Salim, Margot, Roxanne have been fighting in the trenches for over the last 4 months, about how we take this legal win and how do we produce a legislative proposal that represents our values, that brings people home. But also, and I think this is a thing I'm really gonna, illustrate, and I think this is what folks need to understand. We are not only, when we fight these fights in Harrisburg, it's not only about bringing our folks home. It is actually about challenging real, deeply held narratives about our carceral system and changing what justice can mean. And I say that to ground ourselves in the fact that, right, like we are all undoing essentially a half century of carceral logic, right? Logic that has kept all of our loved ones behind bars for decades, for maybe their entire lives since they were 18. And so when we are fighting, we're not only fighting the fight around policy, we're changing narratives, we're changing values. And that is hard, deep work that we have been doing this entire time. And I really want to highlight and celebrate the legislative team here, Sean, Roxanne, Margot, Salim, because they have had to hold some serious tensions and some like real political disagreements, and have done so in a way that demonstrated a lot of patience, a lot of diplomacy, honestly, a lot of times when it wasn't even fucking deserved, to be frank with you all on this call. But it's because we were all clear that, we were fighting for our vision and we were fighting for our folks. And it was important to do that because the reality is, again, going back to the other realm in which we're fighting here, unfortunately, it is not just Republicans now, right, who are conservative on criminal justice. We are not in 2020. We are not in the George Floyd era anymore. We have seen the establishment Democratic Party backslide on criminal justice issues. And when it came to coming up with a legislative solution in response to the Lee decision, we felt that in real time, not only in fighting to get HB 443 introduced, but then to actually, one, get it to be voted on, possibly, to get to an agreement between both the House and the Senate around a proposal that could reflect our values and would not, be something like SB 1400, which is a vile, awful bill. And that was really hard work. It was hard, deep organizing work. It involved having strange bedfellows like the District Attorneys Association, and even trying to get different allies on board, which I'm sure folks have been briefed upon in some of the previous calls. But it was work that was important, that pushed this honestly to its brink, which also did, again, prevent us from passing SB 1400. I want to echo what Sean said, right? Like this 5 years ago, we would have SB 1400. We arguably might even have something worse than SB 1400, frankly. But because of the organizing, the relationships, having allies, myself, even other representatives in office who were willing to organize with us and strategize with us, we were able to not only hold the line against SB 1400, but also, use this political environment to then create some leverage around the bill that was voted on today, HB 1042. So I'm going to talk a little bit more about that because I don't, other folks can talk about like the particulars of the bill, but I want to give you all just a little bit of how we got here. So, we had this timeline of coming up with a proposal by tomorrow. Our goal was to get something done in June during budget because that was when both parties were negotiating. That's when everyone was in the Capitol. We've spent months trying to have conversations about, if not running 443 as written, coming up with a deal with the Senate around numbers that we felt, we could support. And that faced a ton of resistance. It faced a ton of excuses, frankly, for being transparent with you all. But we were not deterred. We kept fighting until the end. Things eventually, due to the Attorney General and frankly, other bad actors coming in and intervening in a discussion, caused us to reach an untenable position, which meant that essentially when we finished the budget, we just sort of assumed, well, I guess this is it. We're going to go to mass resentencing. What happened and transpired in that interim is that because the House did not pass a bill at all, the Senate was able to control the narrative and basically created a political narrative where they, in bad faith, of course, said, because the House has not passed SB 1400 or put up a bill of its own, they are letting, criminals out. They're the ones that are being soft on crime. They're not taking seriously the lead decision, which created a backfire situation, frankly, for our caucus, where now House Democrats were being attacked at home because they did not have a record on felony murder. And so in response to this, now our caucus had motivation to do something to be able to provide cover for members. So 2 days ago, which is kind of insane to think about, 2 days ago, we were given notice that we were going to come into session today to consider legislation around second degree. So with this, us, the collective that was working on this and has been organizing with Rep. Briggs and other leaders in the House caucus, came together and tried to figure out, okay, the House now has motivation to do something. What is a proposal that we can move forward, that we can use our influence and leverage to get them to support, that maintains our values, that will create a legislative proposal that will release as many folks as possible. And we have the organizing ability to get the 102 votes behind, which is how we came up with what was outlined around the 30 years retroactivity for parole eligibility, medical parole, House Bill 150. We've had that in there because, one, it's a bill that we've already passed on record, and we actually passed in a bipartisan fashion. The other reason why we threw this in there was because knowing that we had to negotiate and we have some wiggle room around the retroactive numbers, why not try to also get another opportunity for people to be paroled through medical parole, given that we were able to pass that bill in a way where, we have some latitude in terms of using it as a mechanism to bring folks home. And then, as mentioned, the Pennsylvania Commission on Sentencing, which is a legislative agency that I'm actually the chair of. A quick just sort of 101 on what the commission is. It's a quasi-legislative agency. It is funded and created by the General Assembly. The commission produces sentencing guidelines for the entirety of the courts. So basically what happens is the legislature will pass a bill saying, offense so-and-so is a felony of this degree or this gravity. And then the commission goes and kind of fills in the blanks in terms of what the guidelines of a sentence will be for that. So it actually is a very powerful body in that it is one of the main things that judges use to make determinations about what sentences to hand down in their courts. So we put those three things in there as the possibilities that we could get behind and support. I want to explain why HB 1042 ended up being the vehicle, because I'm sure that's kind of confusing for people. You're probably like, what is this bill? Who's Napoleon Nelson? Like, what's going on here? So the reason 1042 ended up being the bill that was voted on today was, one, there is not currently an agreement on a proposal for a second degree between the House and the Senate. What we did today was essentially just to pass a bill to be able to have the House Democrats on record for doing something. But there is not currently an agreement to run a bill between both chambers. So what this does is, by having this bill that has already basically gone through both chambers and been passed, we can use a mechanism of amending it through basically what's called the Rules Committee, essentially like the final stop before a bill becomes law. We can use that committee to amend this language into HB 1042. Then once that bill is voted on, it then goes back to the Senate for a final vote. So it already bypasses like the committee decisions, having to go through both legislative chambers. It's basically kind of a way to put something in a bill, to send it to the Senate, and in the Senate, if they want to take something, they could vote for it, or they vote it down. So there's a way to basically pass something on second degree, put something on the record in a day, which is what we had to do. So that is why, instead of 443 or another bill, they took this language and amended it into a bill that was essentially already kind of 90% through the legislative process. So we did a lot of work to maintain these things in the legislation. Again, just speaking honestly with you all, there are a lot of members who would have been happy to vote on Senate Bill 1400. But because of the work that's been done, because of the relationships that we hold within the House Democratic Caucus, and even using our ability to organize leadership and understand that for as much as they have to listen to the right wing, they have to listen to the left wing of the caucus even more. We were able to use our power and our collective might to hold the line on these priorities. So we passed the bill today. It now is in the Senate. We'll see what happens. As of 6:45 p.m. today, I have not heard of there being the possibility of a legislative agreement on something, which would lead to the court's process that we've already talked about. But I think by putting this bill out, one, we were able to hold the Democratic caucus to a standard we can support, and we have things that we could possibly put into play if there were to be a discussion about an agreement forward. So I know that was a lot. Appreciate y'all giving me the space, and really appreciate being in this fight with y'all. I feel confident that we're going to bring people home, but also we have changed the politics in this chamber, and that matters for second degree, but it also matters for all the other things that we care about when it comes to this carceral system. So thank you.
Yeah, thank you so much, Rep. Rick. Yeah, I'm going to pass it to my colleague Quinn, and he's going to go over some of the legal next steps that we're facing right now.
Yep. Hello, everyone. My name is Quinn Cousins. I'm a staff attorney with the Abolitionist Law Center, and I was one of the attorneys for Derek Lee in getting this case from the Supreme Court. So I'm going to run through some of the fairly basic things from the legal side of things. We've talked about this a lot in other places and in other communications, but just want to make sure that we're all sort of on the same page, because if the legislature does not act as it's kind of looking likely right now, This battle is going to continue in the courts, and we're going to be ready for it. We're working not just internally with us and our partners, but with a number of other lawyers who have a lot of experience in these things to make sure that we're all very prepared to help all of you and your loved ones get through this process as quickly as possible. Before I get into some of more of the nuts and bolts of what's going to be happening, did want to share with everyone. We've talked about there is a stay on the decision from the Supreme Court. So that's why the legislature had this time, this 120-day period to work on trying to get a deal together. Just a couple of hours ago, the district attorney of Allegheny County filed a motion in the Supreme Court to extend that stay for another 120 days. They're asking the court to extend that to give the legislature more time to act. We don't really know what their motivations are for that. Just another example of the DA's not really wanting to go back to resentencings and wanting a legislative fix on that. We also have no idea what the court is going to do with that, but just wanted to let folks know about that because it is possible that we have another sort of 120-day period where the court is asking the legislature to get their act together and get something passed. Again, we don't know what the court's going to do. It's entirely possible that they just let the 120 days elapse and we go back to the legal side of things. So if they do decide to do nothing to extend the stay and the pause on its ruling ends tomorrow like it's supposed to, here's a little bit about what that's going to mean. So again, the ruling itself, we've talked about this in other places, but it only so far affects Derek Lee's sentence. Everyone who is already sentenced still has a death by incarceration sentence for now. Going forward, everyone who's currently facing a second-degree charge or who will face a second-degree charge in the future will receive an individualized sentence from a judge, just like in every other criminal conviction, where the judge takes into account a number of different factors and gives them a sentence. But for people who have already been convicted, sentenced, and have been in for a number of years, we're going to need to go back into court to get a retroactivity ruling from the Supreme Court so that this does apply to all 1,000+ people who are already serving this sentence. For everyone who's convicted of second degree, whether they're already convicted or going forward, death by incarceration is still a possible sentence according to the Supreme Court right now. So it's possible that people go back, get a new sentence, but a judge decides that death by incarceration is still the appropriate sentence. We're going to, again, do everything we can to fight against that and make sure that that does not happen for people. But according to the Supreme Court, that's still technically a possibility. And it could be a possibility in different counties across the state. So just want to make sure people are clear on that. There's also been some questions about how new sentences will work and when people are going to be parole eligible. There's no minimum sentence right now. The Supreme Court can't set a exact minimum sentence. The legislature can, but if the legislature does not do that, then there's going to be no absolute minimum sentence. It's going to be up to the judge to determine when somebody becomes parole eligible. That's what a minimum sentence is. It tells you the number of years until somebody is allowed to go to the parole board. Another thing that the Supreme Court was pretty clear on is that everybody will still have a life sentence, even if they have the opportunity to get parole. So people will still need to go see parole. They won't get out of prison until parole grants them release. Again, unless the legislature changes that in some way. So even if we get to the point where we're going to resentencings, we think that's very likely, as others have said, that we will get to that point eventually. People are going to be getting something, 30 to life, 25 to life, 40 to life. Everybody's going to be getting a different individualized sentence. All of them will have a minimum sentence of a number of years before they can see parole. And then they will, unfortunately, still have a lifetime on parole, even after they're released. So again, as I mentioned, we need to go back into court to make sure that this ruling applies retroactively. So for anyone whose sentence is already final, there will need to be another court decision that says that it does apply to them and it does apply retroactively. Um, for almost for almost everyone that's already serving a second degree sentence, this will apply. There are a very few exceptions for people who were maybe just convicted in the last year or so. But for most of the people that we know on the inside, we will need that second case. So the normal way that people appeal their sentences through the Post-Conviction Relief Act, which we call the PCRA. It's really difficult for people to get back into court if they've already been in for several years or longer. So if your conviction and sentence have been final for more than a year, in a situation like this, the Supreme Court has to explicitly say that the ruling applies retroactively before you're even allowed to file a PCRA that a judge has to consider. So almost everyone does not currently have a good opportunity to get back into court and get a new sentence yet. So that's why we're working with, again, our partners and other lawyers to get back to the Supreme Court as quickly as possible so that we can get a ruling on retroactivity so that this can apply to all the 1,000+ people that are serving this sentence already. Unfortunately, this is going to require some patience from everyone. Courts move slowly, they move on their own time, and the Supreme Court does not have to take anyone's appeal, any individual case. Of course, we fully expect that they will take a case at some point, but they will do it on their own time, and when they decide to do it, we will do our best to make sure that there's a case that they want to take and that we keep up the pressure on them. And that's why it's important for all of us to kind of keep up the pressure on this fight too, so that they know how urgent of an issue that this is, so that they do take a case as quickly as possible and rule on it as quickly as possible. Even under the sort of fastest possible scenario, we're likely looking at a year or more from now until the court makes a retroactivity ruling. If a case has to go through it's the typical process where it starts in the trial court at the lowest level where everybody is convicted and sentenced, and then goes to an appeals court that's directly above that, and then eventually goes to the Supreme Court. That process usually takes several years from start to finish. So that's kind of the upper end of what could potentially happen and how long this could take to work out in the courts. So just want to make sure everyone's aware that this is not going to happen immediately through the courts for pretty much everyone convicted of second degree, that we will need to be patient while the process works out. However, if the Supreme Court does rule that this applies retroactively, and we do expect that they will, we cannot guarantee anything that the Supreme Court does, but we do expect that they will eventually rule that this applies retroactively. The ruling will apply to everyone convicted of second degree and only people convicted of second degree. So if you're wondering if your loved one's case will be impacted when the court rules that it applies retroactively, if they're convicted of second degree, then the answer is yes. If they're convicted of first degree or third degree or something else, then at this time, the Lee decision does not affect them. And ultimately, we do expect that the Supreme Court will outline a process that's similar to what we saw with the juvenile lifer resentencings after Miller versus Alabama in 2012. And then again, is just an example of how long things can take there. Miller versus Alabama was decided in 2012. Pennsylvania fought the idea that it applied retroactively, and it took another 4 years for the U.S. Supreme Court to say that it did apply retroactively, and only after that did resentencing start. So again, we are trying to make this go as quickly as possible, but we can't control how quickly the courts rule on this stuff. But if we do follow a similar process in terms of how resentencings work as what we saw after Miller versus Alabama in the juvenile lifer cases, the first step is people will need to file PCRAs either on their own or with a lawyer saying that they were convicted of second degree and that they have a right to a new sentence. So that's kind of what kicks off the resentencing process. It's very likely that the DOC will be helping people to get those in. We are working with other lawyers to have supportive materials and resources available to help people file their own PCRAs to make sure that nobody gets left behind. But people will have a year after the Supreme Court decides that it applies retroactively to file their PCRAs to get back into court. After they file those, it will go to a judge in the trial court who will then ultimately be deciding what their new sentence is. Again, there's no set minimum that people will get, so we can't predict exactly what people will get for minimums. The maximum, again, will still be life, and it's possible judges still have the option to give a death by incarceration or life without parole sentence. But people will be entitled to attorneys to work with them and their legal teams to convince the judges to get as low of a sentence as possible. So everyone will be getting a lawyer at their resentencing once we get to that point. Um, and again, people will be working with their lawyers. Their lawyers will be negotiating with district attorneys and presenting their cases to the judges to try to get the lowest sentence as possible. Like Sean said, I think we expect that if we get to that point, sentences in Philadelphia will generally be much lower than the 35 years that was in the Senate bill, on average at least. In other counties, there will still be many people who get sentences that are much lower than that too. But everybody will be getting different sentences. There's not going to be a one size fits all approach. And it's really going to be up to the judge. It's going to be up to a lot of different factors that people have going on with their cases, as well as what's been going on with them since they've been in prison. And again, we're going to be fighting to make sure that all the lawyers that people have will be fighting for the lowest possible sentences, and make sure everyone's equipped to be handling these resentencings. So again, just as a sort of summary of everything, we will need to go back into court to get this ruling to apply retroactively. This will take some time, and it's crucial that we keep up the pressure on all fronts in the meantime. Except for people who were just convicted within the last year or so, and maybe very few others, almost everyone will need this retroactivity ruling from the Supreme Court in order to be able to get a new sentence or go back to resentencing and potentially get an opportunity for parole if the legislature does not pass anything. So people who have been in for a long time and don't currently have a timely PCRA that they can file don't need to file anything right now until we get a retroactivity ruling from the Supreme Court. So there's nothing that people need to do. If people do want to file their own PCRAs, I don't think it can hurt. And I think we generally, as in our discussions, believe that it's not necessarily going to hurt people. But again, people need that retroactivity ruling in order for courts to be able to actually consider their cases if they've been in for a number of years already and don't have a timely PCRA already. So there are some things that people can do to start getting ready for this process, though. Again, it's a little bit far off. We have some time. People will have the right to an attorney to help them through all of these things. But if people do want to start getting prepared, if you want to talk to your loved ones about starting to get prepared, there are a few things that they can start thinking about. One of the main things is just gathering any court paperwork, making sure that they can prove that they were in fact convicted of second degree. That can be a challenge for a number of people, just because of how the courts keep their records, how the DOC keeps their records. So any sentencing documents, any transcripts that people already have, those things can be especially important just on the front end of making sure that they qualify, but also it can be really helpful to the attorneys once they start working on these cases to already have some of that information gathered. People can also start getting documentation together, making lists of any DOC programs they've completed, any educational programs, job training or certificates, organizations that they're a part of, other things that they're involved in, inside or outside, that basically will reflect well on them, that will show what kind of person they are to a judge. Because really, a lot of these resentencings are about humanizing people and making judges see that people are human and deserve an opportunity for release and to be parole eligible. People can start thinking about the people that they've maintained good relationships with on the outside, people on the inside that they've mentored, that have, they've impacted their lives in some way. Even sometimes DOC staff or, supervisors at jobs in the DOC. Just kind of thinking through people who maybe could talk to a judge and tell them what kind of person they are, and can testify in a really supportive way, or at least talk to the attorney and give some insight into what kind of person they are before being resentenced. That can be really helpful to us as we're going through that process, as well as to the judge. And then another big thing is to start thinking about potential release plans, especially for people that have already been in for a while. It's really helpful to know where you're going to live, If you are going to have employment, what kind of jobs you might be able to do, if you have any training for specific jobs, what goals they have and what they might want to accomplish when they're on the outside. Again, anything that can tell the judge what kind of person you are, as well as just showing that there's some stability and you'll have some security when and if you are released. And then the last thing I think people can start thinking about is what they might want to say to a judge if they get resentenced. So everybody has the right to talk to the judge at resentencing and make a statement. So that can be really important and really impactful. So it's good to kind of get a head start on that and start thinking about what people might want to say about themselves, about the original offense, about anything that they think might be helpful. Again, these things are all things that they'll work through with their attorney when they get to that point, but it's something that can be helpful to think through early. And then, of course, we will be keeping everyone informed about what's happening next and what steps everyone might need to take. I'm happy to answer any questions people have on the legal front. And yeah, that's all I have for now. So I'll kick it back to Roxanne.
Thank you so much, Quinn. I know we are late, but if we are willing to do 10 minutes questions, because we did say there would be an opportunity for questions for people who want to stick around. Let me just see if there's like anything that okay. I'm opening up the questions that people have had. I know that Quinn, one person asked like how Derek Lee is doing and whether he's anxious for his resentencing, I guess after tomorrow, whatever it is.
Yeah, I mean, Derek has been preparing for this for a long time. Can't get into any like specific discussions we have or anything, of course, because he's our client. We can't share things without his consent. But Derek's very excited for this. He's super grateful to everyone that has helped make this happen, of course, as well. Yeah, and is really ready to kind of take the next step in this fight as well. So
Mhm.
appreciate you asking. I'll
Yeah.
let him know that people are thinking about him too.
So another question here, I think, is for you as well. Quinn, someone wants to know if we're pushing back on the motion to extend the deadline.
I can't comment on that yet because it just happened. We want to make sure that we talk through what the best approach is for everyone. Again, I do want to kind of emphasize that the Supreme Court only ruled on Derek's case. This stay is affecting Derek's case. Of course, the court gave the legislature time um, to make a legislative fix, but at the moment, anyway, we're thinking that even if the stay is extended, it's not necessarily going to stop us from starting to take the next steps to make sure that the courts take action to make this apply to everyone if the legislature doesn't act. So, yeah, don't know. We're gonna, discuss what position we'll be taking on that and how that will work, but we're gonna keep moving things along in the meantime, no matter what.
Mhm. So thank you. So this is one for the legislative team. So someone is asking if the sentencing guidelines in HB 1042 are 30 years, then what exactly is the Sentencing Commission going to be doing? So I can take a first stab at this, and then Sean can like fill in any gaps that I may have missed. So the bill only does 30 years for people who are currently incarcerated, right? So what the Sentencing Commission is going to be doing is giving guidelines for a sentence for people who have still yet to be sentenced. So people, a prospective statute. So there's two parts to a statute, right? There's one that affects people who are currently inside prison, and then the other part affects people who haven't been sentenced yet, because there are people in the future that are going to be convicted of second-degree murder, and they also need guidelines for that sentence. So that's what the Sentencing Commission would be doing, is determining what the prospective sentence is for people who have yet to be sentenced.
Also, just for context, that was a compromise that was done. It was it was at an impasse. And there were, look, like Rep. Krajewski was pretty clear that we're not just fighting the right. There's some people who are Democrats that still wanted life without parole as an option. And what we were able to do was pause that and say, okay, let's move this over to the Sentencing Commission to continue this conversation. with them while also preventing at least roadblocking life without parole being in the House version.
No.
That's absolutely right. And I think just the only thing to add to that is, that compromise was based on the inclusion of medical release, right? That there's just hundreds of people every year who get sick and die in our prisons. And, we were like, if you're not going to do 25 years, you need to do something to create a pathway for these folks to get out and at their most vulnerable time be, with their loved ones who can take care of them.
Yeah. So another question here. What if we already are in a PCR proceedings and waiting a decision? I think that's for Quinn.
Waiting a decision.
They
No,
already
sorry, I'm
have,
sorry.
they already, yeah. They said, what if we are already in PCRA proceedings and awaiting decision?
Or non-second degree.
Sorry, the question is, what if people are already in a PCRA and awaiting a decision?
Yeah, I guess
What
for an
should
issue
should
that's
they
not
file
related to
something?
second degree or specifically, but have a second degree.
Yeah, I mean, again, we don't think it can hurt to file a PCRA. If you have an attorney, talk it over with them, of course, and feel free to direct them to us to talk things through as well. If you already have a PCRA going, you'll want to talk it through with your attorney to see how that will impact the case. But the way the PCRA is set up, is that until there is a retroactive ruling, if your conviction and sentence are already final, there's not a timely claim for a PCRA under this Lee decision. So people don't necessarily need to do it until there's a retroactivity ruling if their conviction and sentence are already final. But yeah, so again, don't think it can hurt. And it might be worth raising to the judge and seeing if you can get something in that will get people to the front of the line. But the way the law works right now, unfortunately, does not provide a great opportunity for judges to have to consider those kinds of claims right now.
Mm. Yeah, people are also wanting to know, where do they get their sentencing documents?
A lot of folks already have them. So if you already have them in your legal paperwork and stuff, that's mostly what I mean. Just kind of get organized with the things that you have. You can request things from the DOC on the inside as well. Salim, you might be able to talk a little bit more about
No, I mean, you
that
could, yeah,
if you want. But
you could get requested from the DOC. You could also, as long as you got your docket number, write your clerk of court, request those documents. You'll have to pay for them as well.
Yeah. I think, yeah, and then, people want to know, what should I tell my loved one?
I mean, you could tell your loved one that we're still fighting. The fight is not over. There's still work ahead of us, but um, they are one step closer to being seen either by a sentencing court or a parole board. That there is going the sitting stagnant for however long they've been in prison is over. There is going to be some activity in their case, and as when I was serving life without parole, I could tell you the most exciting thing, if exciting is the word, is to know that my case was being re-looked at. My case was ramping back up. The wheels in motion were turning again for me, as opposed to just sitting. So let your loved one know that the wheels of justice are turning. To what Quinn said, what they need to do right now is to prepare themselves. Any programs that they've been in, anything that they accomplished, support letters, community letters, they need to be stacking all of those right now and preparing their mitigation packet, wherever it's going, and whether it's going, eventually will go in front of the parole board or the sentencing court. So that's what they should be doing right now, preparing themselves.
Yeah, I think with that, we can close out for the night. I mean, Slim, do you have any last words for people? If you guys have additional questions, please feel free to reach out to us. We're available through email, and I can put my email in the chat. I think, well, I'm going to be leaving like in a week for parental leave, but um, there will be a message of someone you can contact. My colleagues, Quinn and John Rowland in the chat and Margot are going to be around. And yeah, we are happy to answer questions that people still have.
Yeah.
And
One thing I would say is for folks is this, that look, we are going to have another one of these. We're not going to just shut down. There is going to be activity. So we will continue to have these. We just don't have another date set for one. But what I would also say is that what I said earlier, winning a victory is one thing, implementing it is another, and that this is where we're at right now. The wheels of justice are turning. That's the most important thing. The wheels of justice are turning, and more importantly, the thing that makes this different from so many other times when uh, s- uh, uh, legal case was won in the implementation phase, we were not part of those processes. Now we are part of it. Now we are shaping it. I'm not going to sit here and say we are going to determine it, but we are shaping this process. And that is something that is important for everyone on this call to know, but especially our folks on the inside. So the wheels of justice are turning. As they continue to turn, we will continue to update folks. And like, we're not going to stop this fight until we bring our people home. So let your loved ones on the inside know to prepare themselves. That's the most important thing that they should be doing right now. And also, John Rowland did put something in the chat, is to be very careful of lawyers that are trying to solicit for a lot of money for representation. I would be very cautious um, putting a lot of money out for an attorney right away, right now. Quinn, is there anything that you would add to something like that? Because I do think that that is something that's important. We saw people in the past taken advantage of. And I just really want people to be on point about that.
Yeah, no, just definitely be careful. Like I said, if we do get to the point of resentencings, everybody will be entitled to an attorney. People, you're of course free to hire somebody if you'd like, but I would just be very cautious. And feel free to again reach out if you have questions about things, but generally be very cautious about lawyers right now asking for money.
yeah. And we have an information sheet about resentencing. Can we post that in the chat one more time? You can just download it straight from the chat, and it gives you kind of a breakdown of what's going to be happening, including being cautious of, attorneys that might be, offering their services right now. And yeah, Emily, do you think we can post that one more time, that fact sheet? Yeah, there it is.
Well, also, we could also post that on social media, y'all, and get that out. So we'll make sure that we get this information out, and an email will be coming out soon as well. I think with that, we're going to wrap this up. Thank you everybody for joining us tonight. Thank you everybody for being in this fight for us, and we're looking forward to, freeing some more of our people and fighting some more fights with y'all. Have a good night, everyone. Have a good weekend as well.
Everybody have a
Good
good
night. Thank you for all the hard work.
Thanks, guys.
Yeah.
Hi,
Great to see y'all.
Yes,
Yeah.
thank you.
Good night.
Thank
Good night,
you
and
for the
stay
hard work
strong.
for my
Stay
son.
strong.
Yes.